Imagine trying to run a business that is virtually landlocked. There is one way in and out, but a judge has blocked it. Tonight, Pam Elliott is on assignment showing you how a court can lock you out of your own property.
In 2004, Howard Gray bought this land off Pennyroyal Road with an understanding. He knew the property spanned 2 counties, 2 townships, and was zoned 2 different ways. But he didn't know that down the road, this gravel driveway would land him in court.
Knowing what you know now, would you have bought this?
No.
To better understand Gray's predicament, take a look at this map. Gray's property includes 6.5 acres in Warren County, zoned residential, and 2+ acres to the north in Montgomery County, zoned light industrial. Gray built a home in Warren County and a storage facility in Montgomery County with the understanding tenants, including himself, a landscaper, could use the driveway to access what he called Pennyroyal self-storage.
So you had the blessing of both counties?
Yes.
And now neither is coming to your defense?
Amen.
Originally, Clear Creek Township's zoning inspector gave the Gray family his blessing too. But years later, the matter ended up in the Warren County courts.
He turned out to be wrong.
He is Jeff Palmer, and he's still in charge of zoning for the township. Jill Mead is the township's law director, newly hired to deal with the aftermath of his mistake.
It is a nightmare. I can't disagree.
Neighbors have complained about dust and traffic that endangers children. Mead has pictures of commercial vehicles coming and going near where kids play. A judge ordered Gray to stop using the driveway for commercial purposes. The Court of Appeals upheld that ruling.
Look at the options here, Jill.
They don't have any. I guess that there's an expensive option through Montgomery County, is my understanding, that they have to get through a culvert or a ditch of some sort. And it's unfortunate. This whole string of events is unfortunate, and no one, not Clear Creek Township, not the courts, can deny that there was inherent unfairness to the Grays.
But Mead says the Grays have been in contempt of court by conducting business as usual. However, this week, the landscape changed.
6 days ago when we were here, all we had to work with were these markings that indicated the county line right here. But today, there's a fence. The Grays put this fence up. The problem is the law director for Clear Creek Township says this may not be exactly what the judge ordered.
The Grays were also to have turned over their list of tenants so the township could contact them and make arrangements for them to get their things.
I don't have any place to put my boat now.
Tom Fath has been renting space from Pennyroyal Self-Storage for 5 years. He pulled his boat out after he heard from Gray himself. He's not sure where he'll go from here.
All the enclosed garages for boat storage are pretty much taken at this point.
Yes, a business is lost. How one measures that against the quiet enjoyment of one's residential property, I don't know.
Mead says the Grays can file for a zoning variance, but it's likely the neighbors who have complained already won't go for it. They could put up barriers along their driveway, and that might satisfy the neighbors, but there's no guarantee. For now, the Grays anticipate losing $60,000 a year in rent, on top of being left with a useless $300,000 storage facility.
We're going to still have a mortgage on the property. We're still going to pay insurance on the property, and we're still going to have to pay taxes on the property that we are not allowed to access.
Pam Elliott, 2 News on assignment.